Picture the ultimate nightmare scenario for any defendant in a criminal trial. You are sitting at the defense table. You look up at the witness stand, expecting to see a hostile investigator or a political rival, but instead, the person raising their right hand to swear an oath against you is your own lawyer, the person you hired to protect you, the person you paid to keep your secrets, the person who is supposed to be your final shield against the power of the state. But today, that shield has turned into a sword. What is unfolding right now in the various cases surrounding former President Donald Trump is not just another headline in the 24-hour news cycle. We are witnessing a legal phenomenon that is historically rare and legally catastrophic for the defense: the complete collapse of attorney-client privilege. According to unsealed court filings and testimony, Donald Trump's own attorneys, the people closest to his legal strategy, have been forced by federal judges to testify against him. They aren't doing this because they want to. They are doing it because a court has invoked something called the crime-fraud exception. In this video, we are going to cut through the political noise and the media spin. We are going to open the case files and look at the actual legal mechanics that allowed prosecutors to pierce the most sacred protection in the American legal system. We will look at exactly what these lawyers said under oath, including the contemporaneous notes that could seal a conviction, and most importantly, I'm going to explain what this means for you. For the taxpayer, the voter, and anyone who wants to know if the rule of law still applies equally to everyone, or if there is a special set of rules for the powerful. I'm Daniel Kershaw, an independent legal and political journalist. I don't work for any party, campaign, or cable news network. I just follow the facts, the court filings, and the Constitution. And the big question I want you to consider as we start is this: when the people who know where all the bodies are buried are handed a shovel by the judge, is there any defense strategy left standing? To understand the gravity of this moment, we have to look past the spectacle. If you were watching the news this week, you saw Donald Trump Jr. take the stand in the civil fraud trial. He was there for about 90 minutes, cracking jokes about his makeup, making light of his New York accent, and generally playing it cool. His strategy was simple: blame the accountants. He claimed he just signed what was put in front of him. But while the cameras were focused on Don Jr.'s demeanor, a much more dangerous legal storm had already made landfall in the federal criminal cases. One that doesn't involve deflection, but direct evidence. Several weeks ago, in a move that was initially filed under seal, federal prosecutors made a high-stakes argument. They told the court that Donald Trump wasn't just using his lawyers for legal defense. He was using them as instruments to commit crimes and obstruct justice. Now, normally the conversations between you and your lawyer are absolute. They are privileged. This is a bedrock principle of our system, designed so you can be honest with your counsel. But there is a critical exception: the crime-fraud exception. If a judge determines that a client is using legal services to further a criminal scheme, that privilege evaporates. It's gone. A federal magistrate judge reviewed the evidence in camera privately in her chambers, without Trump's team present, and she made a stunning finding. She ruled that prosecutors had made a prima facie showing that legal services were being used to commit fraud. Trump's team tried to stop it. They went to the D.C. Circuit Court of Appeals. But in less than 48 hours, the appeals court upheld the ruling. That left 3 of Trump's lawyers with a brutal choice: testify against their client or go to jail themselves for contempt of court. They chose to testify. And what they revealed in those deposition transcripts, which have now been unsealed, is what we need to talk about next, because it fundamentally changes the trajectory of these cases. When we look at the transcripts, we aren't seeing vague allegations. We are seeing specific, detailed accounts of a client directing his attorneys to break the law. Let's break down the testimony of 3 specific lawyers whose identities have been protected in some filings but whose stories are now public record. One former attorney testified that Trump explicitly instructed him to lie to the National Archives. The instruction was to tell the government that all classified documents had been returned, even though Trump knew for a fact that wasn't true. But it gets worse. According to this lawyer's testimony, Trump actually showed him where additional documents were being hidden at Mar-a-Lago, and the lawyer wrote down what happened next in his contemporaneous notes. Trump allegedly said, "They'll never find these." And even if they do, I'll just say I declassified them. Let's pause on that. That isn't a legal defense. That is a roadmap of intent to deceive federal investigators. A second lawyer provided testimony regarding the financial fraud allegations. This attorney told prosecutors that Trump personally edited financial statements to inflate the value of his assets before they were submitted to courts and banks. When this lawyer pushed back, warning the former president that submitting false numbers could constitute fraud, Trump's response was chilling to anyone who respects the legal profession. According to the testimony, he said, "That's what lawyers are for, to figure out how to say things that technically aren't lies, even when they are." The third lawyer detailed the obstruction efforts. This testimony describes conversations where the former president asked if there were ways to delete security camera footage at Mar-a-Lago to prevent the FBI from seeing boxes being moved. He also reportedly asked if there were any lawyers willing to take the fall for him if things went south. Now, if you're sitting there thinking, well, it's just their word against his, I need to stop you right there. This is where the legal reality bites. These lawyers didn't just remember these conversations, they documented them. In the legal world, contemporaneous notes are gold. These are notes written at the exact time the conversation happened, long before any investigation started, long before any plea deals were on the table. They are extremely difficult to challenge in court because they corroborate the testimony with a paper trail created in real time. But here is the part most people miss. The damage here isn't just about proving that an act happened. The real catastrophe for the defense is that this testimony destroys the one thing Trump needed to survive: plausible deniability. For decades, Donald Trump has operated with a very specific defense strategy in legal peril. It's called the advice of counsel defense. The argument goes like this: I didn't know I was breaking the law. I'm not a lawyer. I just did what my attorneys told me to do. It is a powerful defense because it negates criminal intent. But that defense is now dead. You cannot claim you were relying on your lawyer's advice when that same lawyer is on the witness stand saying, I told him it was illegal, I warned him not to do it, and he ordered me to do it anyway. From a prosecutorial standpoint, this establishes what we call consciousness of guilt. The testimony shows that Trump wasn't accidentally mishandling documents or making clerical errors on financial forms. He was actively discussing how to hide the evidence. He was discussing how to lie to the National Archives. Let's bring this down to earth for a second. If you are a small business owner or if you're just someone filing your taxes every April, think about this scenario. If the IRS audits you and you say, my accountant made a mistake, you might pay a fine. But if your accountant testifies that you forced them to cook the books despite their warnings, you aren't looking at a fine. You are looking at prison. The law at its core is supposed to be blind. It cannot treat a former president differently than it treats a plumber or a teacher. If the crime-fraud exception applies to regular citizens, and it does every day, it must apply here too. If it didn't, we wouldn't have a republic, we would have a monarchy. There is another layer to this that is deeply troubling for the defense team currently representing Trump. Imagine being his lawyer right now. You know that 3 of your predecessors have been forced to testify. You know that attorney-client privilege is no longer a guarantee. This creates an impossible ethical situation. Lawyers are now wondering, is what he's telling me right now going to be used against me next month? This leads to withdrawals, hesitation, and a breakdown in the ability to mount an effective defense. It isolates the defendant in a way that is almost unprecedented for a figure of this stature. If you are still with me, this next part is crucial, because this ruling doesn't just affect the cases in Washington. It creates a domino effect that could topple defenses across the entire country. This ruling on the crime-fraud exception is now a matter of record in the federal courts. Do not be surprised when prosecutors in Georgia or New York use this exact same ruling as a roadmap. They will file motions citing this precedent, arguing that the pattern of using lawyers to commit crimes is established. They will subpoena lawyers in those states. Once the privilege is pierced in one jurisdiction, it becomes incredibly difficult to maintain it in others. The dam has broken and the water is rushing in from all sides. We also have to look at the human element here. Donald Trump values loyalty above almost anything else. To have his own inner circle, his legal gladiators, forced to testify against him is a psychological blow that cannot be overstated. History and observation tell us that when this defendant feels cornered or betrayed, he lashes out. He attacks witnesses. He tests the limits of gag orders. But every time he attacks a witness, he potentially hands prosecutors more evidence of obstruction. It is a vicious cycle. The more he fights the process, the more evidence he creates for the process to use against him. Finally, this creates a checkmate scenario regarding Trump testifying in his own defense. Normally, a defendant has the absolute right to remain silent, but when the evidence against you comes from your own lawyer's notes, the pressure to take the stand and explain yourself becomes immense. However, if Trump takes the stand, prosecutors will cross-examine him using his lawyer's notes. They will ask, "Mr. Trump, your lawyer wrote here on this date that you told him to lie. Was your lawyer lying? Why would he lie in his private notes before an investigation began? It is a trap. If he stays silent, the damning evidence stands unrebutted. If he testifies, he risks perjury or a disastrous cross-examination. There are no good options left." To sum up, what we are watching is the legal system's immune system kicking in. The attorney-client privilege is there to protect justice, not to hide crimes. When a court finds that a lawyer was used as a tool for fraud, the protection ends. The testimony we now know about, supported by documents and notes, paints a picture of a defendant who knew exactly what the law required and deliberately chose to circumvent it. At its core, this case brings us back to one simple, uncomfortable question. Is the law a suggestion, or is it a wall? If a president can use his lawyers to hide crimes, then the law is just a suggestion. But the courts have spoken, and their answer is clear. You cannot use the shield of the law to hide the sword of a crime. I want to hear from you in the comments. Put aside the politics for a moment. As a citizen who has to follow the rules, how does it make you feel to see the legal system actually applying these standards to the most powerful office in the land? Does it give you hope for the rule of law, or does it concern you? If you found this analysis helpful, if you prefer looking at the court filings rather than just hearing the shouting matches on cable news, please consider subscribing to the channel. We are building a community here that values facts over spin. I'm Daniel Kershaw. Thanks for watching, and I'll see you in the next one.